What you know, alibiers? Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. Good to have you here. It is Monday, March 31st, the first day of jury selection for Lori Daybell there in Arizona. It has been 2,090 days since Charles Vallow was shot and killed by Alex Cox, and it is time for justice. After they were finished this morning with going through jury questionnaires, there was a big hearing to address a lot of the outstanding motions that need to be ruled on in this case now that we are officially at trial. And y'all, it got wild. What I've noticed since Lori started representing herself is when she disagrees with something that's being said or doesn't like the answer, her voice starts to project and it almost gets to the point of her yelling. And today was no different. I'm going to make a prediction that at least once the judge is going to have to send this jury out when she gets worked up. We know Lori doesn't like any of the state's witnesses, and she will be cross-examining them. So it's going to be such an interesting trial. I am most likely leaving Saturday to go out. I'll be there for openings in that first week, and then maybe back and forth a couple of times. I want to be there when the defense case starts. I have a feeling Lori will take the stand, but we will see. Let's jump into this hearing. It's going to be a little bit of a longer episode. At lunch, they had 52 potential jurors in the jury pool just from the questionnaires. Tomorrow morning, they will have more jury questionnaires. And then tomorrow afternoon, they will do the individual voir dire. They start the hearing with the judge saying he wanted to start at 1:30, and it's important to start on time, especially once that jury is seated. He got Lori's objection to the phrasing of the allegations the state has made on that jury questionnaire. We went over that in a prior episode where Lori requested they add to the end of the allegations in bold and underlined that Lori denies these allegations, and the judge denied that. Lori requested to preclude the testimony of Detective Daniel Coons, who will be called as an expert. The state said they did note him as an expert because of his background and training to testify as to trajectory. They did supplement and provide the background of his experience and gave it to the defense 30 days before trial, and the defense did interview him. So the judge asked Lori, what's the objection? Lori says for 5 years, he's been on the witness list to be a regular detective, and now he's being brought on to bring in his opinion as opposed to the facts. She doesn't understand how the trajectory has anything to do with the conspiracy. The judge asks if Detective Coons has testified in that role in the past, and the state says yes. The reason this is relevant is because the defense has claimed this is a self-defense case, so that makes it relevant. The judge asks if the state can provide Detective Coons' opinion, and the state says they put it in a supplemental and it includes his background and his training as well. The judge asked Lori, you've said a couple of different things. Do you think he doesn't qualify as an expert, or are you saying the disclosure came in late and you don't think his opinion is relevant? Lori says she doesn't think his opinion is relevant. He's named as a firearms expert. She says, I don't know if he took a weekend class and that made him a firearms expert. I don't know what his experience is with that. In his CV, it just says firearms expert. The judge asked if she's asked him those questions and then asked who interviewed him. Lori said it was her investigator. The judge asks if her investigator asked Detective Coons questions about his background training or his expertise. Lori whispers to her advisory counsel and says she personally has not listened to that interview yet. He was a witness, and then 30 days before trial, he's an expert, and she says that was my objection. The judge says if that's your basis of the objection, the timeliness of it, the state did comply with the rules as far as the notice prior to trial and gave a summary of what his testimony would be. The judge said he would take a look at it and just put it aside for now. The next issue was Lori's motion to disclose all of the 404B evidence. The judge says he doesn't know the evidence that the state is offering to introduce as 404B bad act per se, but he asked Lori if she's got the state's response, and Lori did. He asked, what specific bad acts do you think should be precluded, or are you asking them to disclose what they're introducing? She wanted to know what prior bad acts they are introducing, and instead she got another theory of the case and didn't think it was 404B evidence. The judge says he agrees with what was listed in their response. I wouldn't necessarily characterize it as 404B, but you've received it and now you're aware of what they're planning to introduce. And Lori says somewhat. The judge doesn't think it's time to rule on that issue. If there are evidentiary objections like hearsay, foundation, those things will be taken up when the state attempts to elicit that information. The next motion was her motion to exclude Kay Woodcock, Nancy Jo Hancock, and Christina Atwood as witnesses. The state filed a response telling the direction that these witnesses will go in, talking about the element of premeditation or motive. The judge asked Lori what is her objection specifically. She says, mine, Your Honor. She says, after their defense interviews, it came to light. And she said, one specifically from Dateline, that they called each other and their information came from each other. The judge is like, I'm in the dark. What information is that? Lori said, I don't know, whatever they're testifying about. None of them have personal knowledge of any crime. The judge says the state isn't saying that. The state is inferring that they have personal knowledge of things that may lead a jury to infer some sort of premeditation or motive. He asked the state, what's your offer of proof that they're relevant? The state says Christina Atwood was present when Lori was speaking about Charles being possessed, which goes to motive and premeditation. And also, those statements were made months before the murder. That will be admission by party opponent and firsthand knowledge. As far as Nancy Jo Hancock, she was the one that had a date with Charles the night before he was shot and killed. She was the last person to see him alive. What she knew was hearsay, but her statements to Charles was that she told him he should tell Lori that he changed the beneficiary on that life insurance policy. For Kay Woodcock, she was the beneficiary of that life insurance policy, which is part of the motive, and she also has knowledge of the victim himself. The self-defense theory, the use of a baseball bat, and Kay can give background information on Charles in that area. The judge asks Lori if she wants any further argument. She shakes her head and pauses and says all witnesses are getting together and comparing notes. She told me this, she told me that. Their information isn't firsthand. They're watching everything on TV and she wants them precluded. The judge tells Lori she can cross-examine them and ask about any biases or colluding with other witnesses. He said that's areas ripe for cross-exam, but not a basis to preclude a witness. He says the three witnesses do have minimal, although very limited, but relevant information to provide, and it could be helpful to the jury in understanding the case. He said she can object to their testimony as hearsay when they're on the stand, but motion denied. The next issue taken up was Nate Eaton's motion to be precluded as a witness. His attorney, Matthew Kelly, was there to represent him. And the judge asked Lori what relevant information would Nate have and why is he listed as a witness. Lori said she just got the filing from Nate last night and hasn't had time to read all the things he's claiming, but there are several things off the top of her head that's relevant. And one thing is he's had this off-the-record conversation with the prosecutor, and she says he's kind of made himself a witness and he's made her a witness. The judge asked Lori, how so? She said, in a sense of if this isn't prosecutor misconduct, one of them will have to testify and talk about how it's not. The judge asked, how does he have relevant information for this case? And he explains to Lori, a witness has some testimony that makes some fact in the case more or less likely. So how does Nate Eaton have relevant information for this case? Lori said her intent is because she doesn't know what the state will put on in their case in chief. So she was going to call Nate for rebuttal impeachment, or laying foundation for interviews because he's interviewed almost every witness on the state's list. And if one of these witnesses said something contrary to what they said to Nate in a public forum, she would call Nate to lay foundation. She did say she found it funny when she read where Nate said it's clear Lori was trying to keep him out of the trial. She said, I had to laugh because it didn't occur to her. You couldn't be in the courtroom if you're a witness. And she said that was not her intention. Now, the judge did say, in theory, Lori is right that Nate could be called to impeach a witness, but that would be after being confronted and the witness denying it. He asked if she has copies of the transcripts of the interviews Nate's done. Lori says she's been watching those herself and making her own notes, so yes. Nate's attorney points out there are specific requirements for calling a journalist, and they don't believe there's any way Lori could meet those requirements. If she wants to call Nate, she would have to follow the requirements of the subpoena law, and then they would challenge it. The judge said Lori could just impeach them with the interview by playing it in court. Lori says, but I wouldn't need him to lay the foundation for that interview. The judge says he's not trying to give her legal advice because she's her own attorney. But if the witness admits that's them in the interview and that's their statement, then that is foundation. Lori says he's interviewed almost all of law enforcement that will testify, so it's not just witnesses, it's law enforcement. The judge says they're witnesses regardless of their occupation. He sees only the narrowest of situations where Nate would be called to testify about impeachment and said Lori would have a lot of hoops to jump through. They'll cross that bridge if it comes, but he doesn't see them crossing that bridge. Lori says, so we just call him from the back, meaning the back of the courtroom. And the judge again says they'll cross that bridge if they get there. The judge did strike Nate as a witness at this time, and he can be in the courtroom. So big win for Nate Eaton. The next issue is the state's motion to preclude disclosing phone numbers and emails to establish foundations for text messages, emails, iCloud accounts, and the state is concerned that there are some victim information that could be displayed, and also safety concerns for witnesses who have attempted to not be a part of the media and would not want their information out there. Lori agrees with this, and the judge says there is a 30-minute delay order on the live stream, and he also has a protective order that jurors cannot be broadcast and the feed cannot broadcast sidebars. He'll order the feed also not show any exhibits showing contact information for any of the victims or the witnesses. Next up was the state's motion to preclude expert witness and her other witnesses, all 12. The state has not received a report yet from Mr. Dworkin, who is Lori's forensic expert. At this point, Lori turns around to her investigator. He gets up and whispers in her ear for a little bit. And Lori says that most likely they're having affidavits from Mr. Dworkin sent over tonight. She said he has found a discrepancy in the information he downloaded and what was turned over by the state, and he wants to explain how that is relevant and what it is. She said they will get it to the state ASAP. The judge says at this time he is inclined to preclude Mr. Dworkin unless something extraordinary happens. He says he offered her a continuance and any disclosure at this point is late. He says he's not going to slam the door just yet because this witness may not have anything useful. But at this time, he's likely to be precluded as a witness because obviously the state would not have time for their own expert to look at his work product. As for the rest of the witnesses, if a witness has not been served with a subpoena, there is no requirement for them to show up for trial. If they have been served, they would need to be interviewed by the state, and then they would need to have something relevant to testify to, nothing based on hearsay. He goes through the list of some of the witnesses, including Tylee's best friend, Baisia Idowahu. The state could not get a hold of her, and their understanding is Lori's investigator could not get her either. Another witness named Gabriel, that was Lori and Charles's bishop at one point. He was actually on one of the body cam videos with Charles after Lori left him. The state says that Lori's investigator could not get a hold of him. And on Saturday, his attorney called the state and said he has not been served with a subpoena. The judge asks if there's anyone on the list they don't object to being called. And the prosecutor says there is minimal relevance from Lori's sister, Summer Shiflett, her mother, Janice Cox, and the state points out that her brother, Adam Cox, is on the state's witness list, so obviously they don't object to him being called. She did speak with Lori's nephew, Zach Cox, who is Adam's son. She doesn't know how there's any relevance to anything he could testify to in this case. She hasn't talked to anybody that has been subpoenaed. And Lori said their subpoena is with OPDS and they should be currently being issued. At this point, Lori gets loud and says the state is saying trial by ambush. How is it trial by ambush when they've interviewed everyone over the last 5 years? They have written transcripted interviews and video interviews with all of them. These witnesses will add additional facts or fill in the blanks the state will leave out of their case in chief. She says the same about her expert, Lonnie Dworkin. She goes on to say, I feel like the state is saying, okay, you want your speedy trial? Well, guess what? We're not going to let you defend yourself. You can't have your witnesses or your expert. Good luck. Have a nice day. The judge says this is why attorneys sometimes take a long time to prep for trial. That's why your prior and your current attorneys were asking for more time, and you can't have it both ways. You want your speedy trial, but you don't want to give notice to the other side. Lori says, I do want to give notice, but the limitations at the incarcerated state where I am and OPDS being late getting me Lonnie Dworkin, I've done everything in my power as a defendant to prepare and give everything I could do within my power with the limitations. I'm incarcerated currently at this maximum security prison jail, and I shouldn't be able to represent myself because of that. She said it negates my constitutional right. The judge says I didn't say that. I said sometimes there are reasons to not go forward to trial as fast as you want. When you say things like they're going to fill in the blanks, that makes it hard to assess what the relevance of their testimony is. Lori says they have relevant information to a lot of factors that I got in the 404B information. For example, the life insurance. My father is a life insurance salesman. He worked with Charles on getting both policies, my $2 million policy and Charles's $1 million policy. He also tried to sell my policy after Charles passed away. He told me to call the insurance company when you're the beneficiary. I didn't know how to do that. My sister Summer has relevant information regarding my brother Alex and the whole situation to what happened on July 11th. They have relevant information as to what the state is accusing me of. The judge says what he is struggling with is just because you say it's relevant doesn't mean it's relevant. He said it may be, but I'm trying to find out the relevancy. What you said about your dad could be relevant. Who's your father? And she says Barry Cox. The judge says it sounds like it just depends on what the state puts forth and if their testimony would be relevant. Lori asked the judge, am I not allowed to defend myself? The judge says you're absolutely allowed to defend yourself, but I need to be sure witnesses have relevant information. You have the right to interview their witnesses, and they have a right to interview yours. Lori says they've already interviewed them. The judge says, I'm not talking about interviews from years ago. The state has the right to interview them before they take the stand. The judge said, maybe we just take this up as we progress through trial, but these people may or may not be served. The state says they've made a good faith effort, and the defense investigator has too. It seems to not be following the rules of procedure or evidence. If they find these people, at some point, they can try to preclude them. They can't find these people, and they've had 4 months to do so. Precluding them is proper. The judge said he would preclude anybody who doesn't interview with the state. He wants to punt this a bit. If they don't show up to court or they can't be found, they can't testify. So he puts Lori on notice that if the witnesses aren't served and don't submit to interviews, they will be precluded. And if they do interview, he has to decide if their testimony is relevant. He says Summer, Adam, and Janice may have minimally relevant information. The rest will have to be taken up later, but it's not going to be when you're ready to call them in as a witness and the state hasn't interviewed them. Lori says she's limited in what she can do. She would call them on the phone and they would probably answer her call. But she says her paralegal and investigator are working overtime and they have other clients. So he really didn't rule on that. He left the door open, but I would venture a guess that most of these witnesses will not be allowed to testify. The next motion is the defense motion to dismiss the case for violation of attorney-client communication. And this is where it got heated, y'all. The judge says if you have an attorney in Idaho who is working on an appeal, the information turned over from the jail was about setting up a confidential line for the two of you to talk. So how does this arise to a nefarious interception? It was put on a public chat system the jail uses. You know it's not confidential, but the substance has nothing that rises to that. Lori says, who's saying they're not confidential messages? The judge says, your attorney. He goes on to read from the transcript where her appeal attorney in Idaho says he's working on getting a confidential attorney line set up, indicating this message is not confidential. He reads from another message. Her Idaho appeal attorney tells Lori, I hope things are getting a little better. Still working on getting a legal line set up. Lori says her attorney got a letter from the Maricopa County Sheriff's Office that said your number is now set up for confidential communications. She says, when I call or text someone from a tablet, when he got that letter, now all your calls will be confidential. But the judge says when the line was approved, there were no other disclosures of messages between you and him. Lori says there was. The judge says he sees up to December of 2023. Lori says the prosecutor who obtained these, her protocol wouldn't be to ask the court how to do this if she's subjecting herself to privileged communication instead of reading and assessing herself if these are privileged. I have no other way to do this because I was brought here to Arizona to deal with this case. It's a problem. She got them from the Maricopa County Sheriff's Office. She read them, put some of them into her motion, and now his IP address is exposed to the public, which is a federal offense and a huge problem. The judge tells Lori, you just reminded me, when his number was approved, he sent messages from a different IP address instead of the number that's privileged. He is the one that disclosed or violated the confidential nature of the message. I don't see how any of these inadvertent intercepted messages are being used in any way by the state. Lori says just the state reading them is a violation. But the judge says not if they're not done through a privileged setup the way they're supposed to, which your attorney acknowledged. Lori interrupts and says, my understanding was that phone number was now privileged. When she gets the message, she calls that number through her tablet. The judge says if your attorney has it set up where the messages aren't being sent and received through the phone number that was designated as the privileged line, but through different IPs, the system doesn't know that. Lori says, I didn't know that. There's no way for me to know that from where I am in my cell. There's no understanding for that. I assumed he was getting them on his phone we were using for attorney-client privileged information. And is the state giving these messages to Idaho? Are these getting dispersed? I'd like to know that. Where are these going? Is there a warrant or subpoena to get these from the Maricopa County Sheriff's Office? I didn't see anything warranting them getting these from Maricopa County Sheriff's Office in the first place. At this point, she's yelling through this whole argument. The state says their motion covers the law under this. Lori and her attorney were giving information. Whether she or her attorney understood it was phone calls that were covered, it's not just Lori, who's not following procedure to communicate. I disclosed them before I looked at them, and I sent them to her because I have to. She can't meet her burden to show there's any legal advice in these messages, no privileges. It is setting up times to call and speak to each other. The judge asked if the 3 messages in her response were all, and the state says there's more. Lori interrupts and says that there's privileged information going forward past December 2023, and she says the state is now testifying for her attorney. The judge tells Lori he is not going to rehash this, but essentially your attorney is not using the system correctly, and you need to take that up with your attorney. He is using different IP addresses and not messaging through that protected phone number, and that's the problem. Lori says, how is he using it incorrectly? The judge said, I just told you. He's not messaging through the protected phone number. He's using different IP addresses. Lori asks, how can you message other than with the phone number? I don't understand that. The judge is like, me neither. But if it was her attorney's cell phone and that phone number, it would be the same IP address for each communication. But he points out there are 4 or 5 different IP addresses on these messages. Lori asked the judge, where are you getting the IPs? And the judge says, from your attorney's messages to you. It's listed on the messages to you. The IP for the device being used is listed. Lori says, so the prosecution is reading them and they're not privileged. And the judge says they are not privileged if your attorney is not using the program correctly. He points out the state cannot use any of these messages at trial, but it's not bad faith if her attorney is not using the system correctly. Lori asks, how is he not using it correctly? The judge says, I don't know how else to explain. I've told you 5 times. Lori asks, are these messages being sent to prosecutors in Idaho because that affects my appeals case? The state says they have only been sent to Lori. The judge says the state can't use these communications at trial, but the messages were not purposely sought out by the state either. Motion denied. The next issue is the motion to dismiss for prosecutor misconduct. The judge said he rules the defense can investigate. Your complaint is they didn't provide those public documents to the defense, and that is more of a civil issue. Lori says that's not the complaint itself, but the judge says that's your first paragraph, and I want to take each allegation one at a time. Lori says her complaint is the interference by the state, Miss K in particular, and interfering with us trying to do our own investigation. It's a violation, and she did do it, and she did it on purpose, and we weren't allowed to get anything. I don't know what she did to stop Chandler and Gilbert to stop them, but we were cut off. The big video from Gilbert, that's what we were trying to get. They should not be able to interfere with that. That's one of the reasons all of this has taken so long. She rapid fires, we haven't been able to get it from Chandler, we haven't been able to get it from Gilbert, and she goes on for a hot minute. The judge says when your prior counsel put in for them in September, the state said they obtained it and gave it to your attorneys on October 1st. So why are we waiting to address that now if you have an issue? Lori says she doesn't have an issue, and the judge says, why not file a motion in November or December? Lori said she did, and they discussed this. The judge says, but you're saying that this is prosecutor misconduct, and Lori says it is. The judge says, well, this is the first I'm hearing about it, and if Chandler and Gilbert do not honor a public records request, there is a process. Lori says, which is what? And the judge tells her he's not giving her any legal advice. The judge says your allegation of misconduct as far as Nate Eaton. The state notified him he would have to be served with a subpoena. So how is that improper? Lori says it's taking her word that that's what happened. Nate isn't here to testify, but I would like one of them to get on the stand to say she wasn't giving him legal advice. Who says she wasn't? We don't know if she told him, don't come to the March 18th hearing because they're going to serve you. You're taking her word for it like you took her word that there's only 6 emails. You're taking her word for it as an officer of the court, and I think she should be sworn in. The judge says, you want me to take your word? He must have gotten these things from Miss K just because his motion says he thinks you're trying to keep him out of the courtroom. I don't know why you take the jump. It came from her. He also hired an attorney to say the same thing. Even if she said you have to be served, that is not an ethical violation. Lori says giving legal advice is not an ethical violation. The judge says stating the law is not. If the prosecutor told Nate, don't show up so you're not served, that is an ethical violation, but we don't have that. Lori says, how do we know we don't have that? And the judge says, you can interview Mr. Eaton or your investigator can. Lori said, you just precluded him as a witness, and the judge tells Lori, you can interview him. Lori says, so even though he's not a witness, we can still interview him. And the judge is like, sure, have your investigator call him and ask about the conversation. The judge denies the motion. There was a hot mic moment where Lori says, of course. The last motion of the day is the state alleges 7 felony convictions in Idaho. And under Rule 609, the court finds limiting the number of convictions and the nature of them to be appropriate as not to be overly prejudicial to the jury. The jury should know the defendant has been convicted of at least 1 felony, and he's inclined to limit them to 2. The state says the court should allow 3. There's multiple dates and victims and distinct incidents, and it would be appropriate when talking about the credibility of the defendant to let 3 in. The judge looks over the dates and the counts, and a couple have dishonesty built into them. He mentions first-degree murder and grand theft by deception. But this is only relevant if Lori decides to testify. Lori asked all of the felony convictions to be precluded, and Lori says she hasn't had time and she wasn't planning on talking about this today, so she said they can look at her reply that she filed. The judge says they can talk about this later if she does decide to take the stand. They talk about some logistics for trial, asking if the judge has reserved 1 row for the next of kin. The judge said they will put up signs, and the first row on both sides will be for immediate family, next of kin, and then the last row on both sides will be for media. The middle rows will be a first come, first serve general public area. So if you're planning on going, I would definitely say there's going to be a line to get in here. I know of people who are traveling from different states to attend. It's going to be crowded. Just my 2 cents for those of you who are thinking about coming. The state asks about Lori's parents and her sister, and the judge says if they're witnesses, they will not be allowed in the courtroom. And the state says they're invoking the rule of exclusion. The judge asks Lori if she understands this, and she does. Lori asks about restraints and tells the judge, you said at the sheriff's discretion that deputies can be placed at exits. And if there is an armed guard, there's no need to wear the belt. The belt, by the way, it's essentially like wearing a taser around your waist. The judge tells Lori you don't have to wear leg restraints, but you have to wear the belt. It will not be visible to the jury to where the leg restraints would have been. It's up to the sheriff's office if they want to position guards, but Lori says they recommended if there's armed guards stationed at the exits, she won't need to wear the belt. The judge tells Lori, it's my order that you wear the belt. Think Lori might be a little nervous about the wearable taser. We will see what happens this week and how far we get in jury selection. Maybe we finish up. You never know. When I was in Boise for her trial, I would go out to restaurants or stores. People would ask where I was from, what I was doing there, and I would tell them, and you would be surprised how many people had no clue who Lori Vallow was. So that's it for today. Hope you guys have a good rest of your evening, and we will see you soon.